Welcome to EPG Pathshala. This is Professor Arvind Tiwari. I am Professor of Criminology, School of Law, Rights and Constitutional Governance, Tata Institute of Social Sciences, Mumbai. I will discuss on the module entitled Premature Release of Prisoners in India, a Human Rights Perspective. The structure of the module is like this. Introduction, the origin and normative framework of premature release, aims and objectives of premature release, its types, the guiding principles for premature release of prisoners, the present status, the recent developments, and problems in effective realization of premature release of prisoners, and the human rights perspective, and particularly the initiative taken by NHRC would also be discussed, and in the end the summary of the module. Now I will start. In recent years, the protection of human rights of prison inmates has emerged as a vital issue in criminology and criminal justice. In India, the concept of premature release of convicts is synonymous to the internationally recognized concept of parole. Release of prisoners prematurely is a concession or privilege extended by the state, and prisoner cannot claim it as a matter of right. It is based on Reformation philosophy, which advocates that once the prisoner has absorbed of his criminal tendencies through correctional treatment and the chance for repetition of crime is minimal, confining him in prison is futile. The objective of parole in India is realized through the review of sentences undertaken in accordance with the special enactments, rules or orders formulated by the state governments. Premature release or parole in 4 states, namely Haryana, Madhya Pradesh, Punjab and Uttar Pradesh, are known as prisoners released on probation. These states have incorporated the procedure for premature release in their special laws, while others incorporated the same in their rules or jail manuals. The system provided for differ from state to state so far as the eligibility criteria of persons eligible for consideration of premature release, the composition of sentence review boards, and the guidelines governing the question of premature release. But it is seen that more often this system or procedure provided for is not being followed meticulously, so much so that the sentence review boards are also not meeting at regular intervals. Now I will talk about the origin and normative framework of premature release. The Indian penal system begins with the principle that an offender sentenced to imprisonment must serve his period in full before he could be released. There was no way of shortening the term except through pardon by an executive authority authorized in that behalf. As modern principles of prison treatment begin to take shape in the early part of the 20th century, the necessity for legal devices to effect premature of certain prisoners about whom it could with some certainty be predicted that they had reached a stage at which they could be released with benefit to themselves and safety to the society was realized. It must be mentioned here at this time in the history of criminology that up to a point of time, correctional changes in an inmate became very effective, and after that period, holding them in the institution became counterproductive. In India, the ball was set rolling by the Indian Jail Committee 1919-20. The committee suggested that the sentence of every long-term prisoner would brought under revision as soon as he has served half of the period awarded by the court in the case of non-habitual convict and 2/3 of the period in the case of habitual convicts, provided in both cases that remission earned but not remission granted in celebration of public events should be included in calculating the period undergone, and provided also that no sentence should come up to the revision until a period of 2.5 years, including the remission has been served. For purpose of granting premature release, the committee recommended that there should be constituted in each province a revising board which might be constituted either on a provincial basis or on a local basis. The committee also recommended the appointment of parole officers who should be attached to prisons and exercise supervision over prisoners released on parole. Subsequently, several state-level prison reform commissions and committees, All India Jail Manual Committee, the Central Advisory Board on Correctional Services, and the Working Group on Prisons appointed by the Ministry of Home Affairs during 1972-73 dwelt the length on the procedural aspects and the advantages of conditional release of prisoners, while at the same time voicing the need for a liberal attitude on the subject. While reviewing premature of prisoners, the Mullah Committee in its report recommended rules for premature release of prisoners. More recently, the Model Prison Manual 2016, formulated by Ministry of Home Affairs, Government of India, New Delhi, has included a chapter 28 on premature release. The chapter has prescribed the objective and detailed procedure for premature release of prisoners. This manual has also been circulated to all the states and union territories for streamlining their jail manuals in tune with the new model jail manual that contains current penological and criminological thinking. Now I will discuss about the aims and objectives of premature release. According to Model Prison Manual 2016, the main objectives of the premature release are: number 1, the confinement of the criminals beyond the time of their reformation is unjust and inhumane and counterproductive to corrections. There is no point in keeping the convict in prison where he is not a threat to the society. Number 2, to allow the convicts to be with their family and fulfill their family's obligations. 3, to reduce overcrowding in prisons and the cost of prison administration. 4, confining the prisoners who are also sick, infirm and incapable of committing any crime is a liability to the states. Now I will describe about the types of the premature release. Premature release of prisoners can be of following 4 types. 1, by way of commutation of sentence of life, convict and other convict under section 433 of the Code of Criminal Procedure 1973 by the state government. 2, by way of remitting term sentence of a prisoner under section 432 of the Code of Criminal Procedure 1973 by the state government. 3, by order of the head of the state passing exercising power under Article 72 or Article 161 of the Constitution of India, as the case may be. 4, premature release under any special law enacted by the state providing for release on probation of good conduct prisoners after they have served a part of the sentence. Now I will discuss the guideline principle for premature release of prisoners. 1, whether the offence is an individual act or crime without affecting the society at large. 2, whether there is any chance of future recurrence of committing crime. 3, whether there is any fruitful purpose of confining of these convicts anymore. 4, whether the convicts have lost potentiality in committing crimes. 5, socio-economic condition of the convict families. Now I will discuss about the present status. There are at present 4 states in the country, namely Haryana, Madhya Pradesh, Punjab and Uttar Pradesh, which have enacted special legislation on the subject. The legislations are titled as the Punjab and Haryana, the Good Conduct Prisoners Probation of Release Act 1926, the Madhya Pradesh Prisoners Release on Probation Act 1958, and the Uttar Pradesh Prisoners Release on Probation Act 1938. Premature release of prisoners in these states are effected in the case of those prisoners in whose case it appears to the state governments that the prisoners concerned are likely to abstain from crime and lead a peaceful life. In other states where no such special enactments exist, the rules and procedures for the premature release of prisoners are contained in the state prison manuals. For effecting the premature release of such prisoners, each state has constituted a sentence review board or advisory boards consisting of the Minister for Jails or Chief Secretary or Jail Secretary, Home Secretary, Inspector General of Prisons as the chairperson, District Magistrate and Superintendent of Police within whose jurisdiction the prison is situated, the Session Judge of the same district and a non-official person nominated by the state government. The Superintendent of the Central Jail or the District Jail, as the case may be, acts as a Secretary of the Sentence Review Board. Thus, presently, there is no uniformity in composition of sentence review boards in the country. The Honorable Supreme Court, clearing a major misconception in a trend-setting judgment, has held that the law does not confer any right on a person serving a sentence for life imprisonment to be released from prison after 20 years of incarceration. It is noteworthy to mention that the Apex Court time and again interpreted that life term meant a sentence that stretched over the remaining period of the convict's life and not 14 or 20 years in jail. In a recent case, Mohammad Munna versus Union of India and others, with Karthik Vishwas versus State of West Bengal, the Supreme Court observed that there is no provision either in the Indian Penal Code or Criminal Procedure Code whereby life imprisonment can be treated as 14 years or 20 years without there being a formal revision by the government. Thus, it is clear that the appropriate government may revise the sentence through the procedure established by law. Until the revision of sentence is not done, the prisoner cannot claim his or her early release as a right. However, it is a human right issue that the case of eligible prisoners shall be placed on time before the Sentence Review Board with all relevant papers. Now I will discuss about the recent development on this issue. In recent years, some state governments such as Haryana, Jammu and Kashmir, Uttar Pradesh and Punjab etc. have granted clemency to several convicted prisoners indiscriminately. Such cases have happened and continue to take place in other states too, all guided by the same motives of politics or nepotism. In one of the cases in which Haryana State Governor granted pardon to prisoner convicted for life imprisonment, the Supreme Court quashed the governor's order and held that the constitutional power conferred on the governor was amendable to judicial review on certain limited grounds. The court further held that, bearing in mind the parameters of judicial review in relation to an order granting pardon by the governor, when we examine the case in hand, the conclusion is irresistible that the governor has not applies his mind to the material on record and has mechanically passed the order just to allow the prisoner to overcome the conviction and sentence passed by this court. The court further held in its May 1st, 2000 order that the entire file has been produced before us, and we note the uncanny haste with the file has been processed and the unusual haste and zeal shown by the authorities in matter of exercise of power of pardon. Now it is clear that there is no uniformity in rules regarding premature release of prisoners. The states are interpreting section 432, 433, 433A of Criminal Procedure Code and special legislations in their own ways. Now, I will talk about the problems in effective realization of premature release of prisoners. In an effort to facilitate the prisoners' smooth reintegration into the mainstream of society upon their release, premature release is one of the important measures. However, this facility is confronted with the following problems in its implementation, such as in absence of clear-cut policy and procedures, the system operates under a cloak of secrecy. Improper selection of prisoners by jail authorities because of political pressure or corrupt jail culture. Next is premature release of prisoners is primarily based on the reports submitted by the police authorities through district magistrate of the district in which the prisoner was convicted and the probation officer as to whether prisoner may be released or not. In practice, these reports are adverse if the prisoner's families do not pay bribe to those authorities. Inappropriate composition of sentence review boards. Then next is negative public perception. Next is lengthy procedure involved. Now, there is a need that social workers and NGOs pay little more attention in this process. The staff should be adequately trained so that they can supervise the prisoners released under this scheme. Now I will talk about the human rights perspective relating to the premature release of prisoners. Several international conventions, guidelines, and rules exist to ensure human treatment to the prisoners. In this general comment on Article 10 of the International Covenant on Civil and Political Rights, ICCPR, the Human Rights Committee held it supplements Article 7 or torture for all persons deprived of their liberty. The prohibition of treatment contrary to Article 7 on prohibition of torture is supplemented by the positive requirement of Article 10(1) of the Covenant that they shall be treated with humanity and with respect for the inherent dignity of human persons. Detention of persons in prison is a part of the administration of justice. The subject of human rights and administration of justice, therefore, deals with the protection of persons in prisons. Standard minimum rules for treatment of prisoners, now known as the Nelson Mandela rules since 2015, Code of Conduct for law enforcement officers, standard minimum rules for administration of juvenile justice, Convention Against Torture of the United Nations are all international instruments dealing with the protection of persons in prisons as part of the human rights in the administration of justice. Even without any express domestic legislation to make them a part of the domestic law, these provisions dealing with the human rights of prisoners by virtue of the Visakha judgment have all become part of the constitutional guarantee under Article 21. The wide expanse of these provisions provide a solid legal foundation to the prisoner's rights and leaves no doubt that every prisoner is entitled to the same, and the human rights even of a prisoner are curtailed only to the extent necessary because of the incarceration. It has to be remembered that a person is sent to prison as punishment for an offence of which he is found guilty or is facing trial, and not for punishment independent of that cause. Accordingly, a prisoner is entitled to all human rights within the limitation of incarceration. A brief resume of some of the above international instruments is useful. So now I will explain briefly the standard minimum rules for the treatment of prisoners, now known as Nelson Mandela rules. As the title indicates, are the minimum conditions which are expected as suitable by the United Nations. These rules require that different categories of prisoners shall be kept separate, their accommodation shall meet all requirements of health, etc. Every prisoner is to be provided separate and sufficient clean bedding and food of adequate and nutritious value. Special care of women prisoners would be taken. Prisoners shall be allowed to contact with the outside world, including premature release, and the prison administration would comprise of suitable professionals sensitive to the needs of the prisoners. These are the stated minimum conditions which must invariably be satisfied. The right of the prison inmates emanate from these duties of the detaining authority. The prison statistics and related researches in India and elsewhere indicate that if well prepared, convicted prisoners are diverted from custodial sentence to community-based correctional programs such as premature release and open prisons, etc. The prisons can be decongested, and human rights violation resulting from inadequate infrastructure such as accommodation, food, clean water, proper health care, etc. can also be prevented. Now briefly I will discuss about the initiatives taken by the National Human Rights Commission to streamline the system of premature release of prisoners. The NHRC has formulated the guidelines. The guidelines cover matters relating to the composition of the state sentence review board, the periodicity of its meetings, the eligibility, ineligibility criteria for considering premature release, procedure for processing the cases for consideration by the review board, and the procedure and guidelines for the review board. They circulated these guidelines to all the states and union territories for implementation. These guidelines shall be implemented by the states, and wherever the existing provision of the rules are inconsistent with any of the aforesaid guidelines, state government shall make appropriate modifications in the rules and implement the review board, being the welfare of the prisoners and the society at large. Now I would summarize this module. It has been recognized through research studies that prolonged imprisonment does not serve the purpose of reformation of prisoners. Rather, it has been observed that premature release of prisoners increases the chance of reformation and rehabilitation, and also the risk of their recidivism decreases. As such, the release of an inmate before an expiry of his or her sentence under supervision is seen as a logical step in the total correctional processes, designed particularly to assist the prisoner to become a productive, useful and law-abiding citizen. It will also avoid pains of imprisonment and human rights violations during incarceration. It is believed that the conditions imposed upon their release are close to those they will again experience as a free citizen after the expiration of their sentence. At the same time, for a prisoner, premature release is an opportunity to test his or her self-control and ability to adjust in the community. For society, it offers immediate protection through a degree of control over the prisoner's behavior and long-term protection through a reduced likelihood of recidivism. Offenders can best be helped to become law-abiding citizens in the community rather than in the prison. The most important aspect of premature release is its efficacy. When well administered, it assists the prisoners to successfully readjust into community living. The conduct of the prisoners while in jails is an important factor as to whether they have lost their potentiality in committing crime due to long period of detention. Thus, the prison and police officials in collaboration with NGOs and social workers could play a proactive role in effective realization of premature release of prisoners. In streamlining the system of premature release, it would be imperative to evaluate impact of the NHRC's guidelines on premature release of prisoners through empirical research studies. It is also a need to rethink the methods of reducing overcrowding in prisons, such as release of some well-prepared prisoners through premature release procedures. Optimum utilization of the procedures relating to premature release of prisoners can reduce the overcrowding in the prisons, as the convicted prisoners consist of approximately 25% of total prison population. Many lifers and long-term prisoners can be released on premature basis if their cases are handled properly and placed before the Sentence Review Board on time. A non-official member from academia or NGO working in the field of prison or correctional administration shall be appointed in the Sentence Review Board. Besides, police report shall also be obtained from NGOs and social activists working in the field. Further, to ensure better efforts and measures for protecting the rights and dignity of the prisoners and to facilitate the goals of their reform and rehabilitation, a whole range of programs will have to be implemented. This would include more resources, better training for the staff, provision for rehabilitative opportunities, and above all, the understanding of all concerned that if a prisoner is not reformed or rehabilitated properly, he could pose an even greater danger to the society when he is freed. Every reformed and rehabilitated prison inmate is an asset instead of continuing to be a burden to the society. Thank you.